May it please the court, my name is Chris Kimball, and I represent the appellants, Nephrology Associates and Renal Care Group, Inc. I'd like to reserve 3 minutes, please, ma'am, for my
You say
rebuttal.
3 minutes?
3 minutes.
Okay.
Thank you. This appeal seeks a consistent application of this court's precedent in Key v. Evan B. Raskin to decide the identical issue that was presented in that case is presented in this case as well. And that's whether a lease amendment entered into by the same parties for the same property is a renewal or extension entitling the appellee to a real estate commission. Below, the Chancery Court examined 18 lease amendments. It looked to see if they were renewals under Doric Building and Key. The appellants won 10, we lost 8, and we appealed 7 of those. The appellee did not appeal any of the 10. The Chancery Court's application of Key was problematic in that it was inconsistent. It varied from lease to lease. For example, the Chancery Court found that the addition of 150 square feet in the Gallatin location was a substantial change, but it found that the addition of 1,600 plus feet in the East Nashville location was not substantial. There are other inconsistencies in the decisions that we believe calls for this court to establish a bright line in the case law to bring some clarity and guide the lower courts towards more consistent results. And that clarity would involve deciding what does any greater rights mean under Doric Building. Turning now to Key, and what I'm about to tell you, the appellee does not challenge at all in their briefs. The Key Court quoted Doric Building for the rule that a subsequent amendment for a same property between the same individuals is an amendment if the amendment confers any greater rights or responsibilities on the parties. That's the test that Doric Building established, and that's the test that we believe, the bright line that we believe this court should now draw. Key did not expand the Doric Building test to change the threshold for a new lease from any greater rights to substantially greater rights. But both of those cases, though, talk about the substantial nature of the changes that they looked at. And we believe this may have confused the Chancery Court. What the Key Court called substantial changes perhaps could more accurately be called material changes, changes that matter, changes that typically are the subject of negotiation. For example, amending a lease to change the address to which a notice is required to be given under the lease is not material. However, there are changes to leases that are material, and some examples of those taken from Key and Doric Building are examples like decreasing the rent by $10,000 a year. That would be material. Changes in rent calculation methodology.
Would $5,000 a year be material?
I think $100 a year would be material because it
would
constitutes any changes.
Would $1 a year be material?
It would be material because if it creates any greater rights, and that's the test that Doric Building established, any greater rights would result in a new lease. If there was, however, an extension, an exercise of an option, for example, that changed none of the terms in the lease, obviously that would not be. But when the parties come together and they make an amendment that does something like the Doric Building Court or the Key Court found, changing rent calculation methodologies, annual rent adjustments and the like, those all constitute substantial changes under Key and Doric Building.
What about the unless language here, though, the labeling issue? And if you call it a renewal, if you call it an extension, why isn't that controlling? And why isn't, if I've reached a new agreement with my landlord and we called it a renewal, and maybe there was a substantial change, but we labeled it a renewal, we labeled it an extension, isn't that controlling?
It would be if the unless clause applied, because that's what it says. However, the unless clause is dicta. It did not play any role in the analysis or in the decision in Doric Building at all. So it's
Doesn't
not
it
binding
make
on this
sense
court.
as the right approach, and in terms of how we understand these provisions? Maybe it would help me in terms of understanding this if we took a step back. Outside of the context of these bounties that are essentially being paid, these payments for the services that were rendered here, do we really care, or why would we care, whether something's labeled an extension, a renewal, or a new lease? Is there any independent legal significance to those labels outside of the context of what we're looking at here? I understand it matters here and a lot in the context of this case, but in normal circumstances as a landlord, as a tenant, does it matter whether we call something a renewal or whether we call it a new lease?
I think if you use the express language under the unless clause and you say it's a renewal or an extension in the amendment, then perhaps if the unless clause were the law in Tennessee, that would matter. However, none of these leases say that. What the Chancery Court did is not look to see if any of these leases expressly state it's renewal or extension.
So, counsel, what I hear you saying then is there's no legal significance of this terminology outside of this framework here. It doesn't really matter to anybody walking around on the street whether or not it's a new lease or renewal.
I think it would matter, no sir, but I think it would matter a lot to people who work in the real estate industry. Because
So these are terms of art?
they are terms of art.
Okay, so where do we go to find what the meaning of the terms are? Do we have expert testimony telling us or explaining to us what these terms of art mean in this case?
We don't. What we do have is Key and Dork Building establishing the definition for renewals or extensions.
So you've got appellate court judges telling you what terms of art mean in the real estate industry.
That's correct.
That seems like a bad idea.
It may be the case, Your Honor. However, the Dork Building Court felt it was sufficient. The Key Court felt it was sufficient to establish the meaning of those terms. But the application of the unless clause can lead to some pretty absurd results that would have an impact on the real estate community. Because remember, Key and Dork Building have been the law in Tennessee for 27 and 31 years respectively.
Isn't that entirely within the control of the parties? And if I have one of these types of agreements where somebody's going to get paid an additional amount if it's a renewal, but not if it's not a renewal, I don't want them to be paid. I don't think they should continue to be paid. I think we're too far downstream. Why don't I have a responsibility as a tenant in reaching an agreement with my landlord that we're not going to call it a renewal? We're going to call it a new lease. We're going on the top of the agreement. It's going to say new lease. And if I instead say renewal, or I say renew or extension or extend, why is that not binding me to make that payment? I mean, there's nothing that legally requires me to call it a renewal or an extension as opposed to a new lease. Why am I not simply, at that point, I just haven't been sufficiently responsible in terms of how I've handled the lease agreement?
Well, that certainly is a possibility. They could do that if they wanted to. The problem is the law doesn't require it. The law allows people to use terms of art and lease according to their ordinary common understanding. And
doesn't
the same
Doric
logic
require
would
that?
actually...
And doesn't Doric require that with the unless language in the case? I mean, it's sitting out, unless I call it a renewal, unless I call it an extension, and and it's sitting out there as dicta, but if it is your argument, and the other side's going to disagree with that, but if I'm drafting a lease and I put in the word renew instead of new lease, why am I not bound by that?
Because the Doric Building Court could have worded the unless clause differently if it wanted to. It chose the words expressly states it's a renewal or extension. It didn't say has the effect of extending the lease.
None of these have that express language. None of them say extension. None of them say renewal.
That is correct.
Okay.
None of these leases in this case. But also, neither does the NNA agreement under which Mr. Tomlin claims. It contains the same language that Doric Building contain, and that is you'd be paid a 4% commission on renewals and extensions. If he wanted to say what is not the law in Tennessee, which is if there's an extension of a lease between the same parties and the same property, then that is not a new lease. That is by definition an amendment or a renewal or an extension rather, right? The law in Tennessee is not that. So that works both ways. They chose not to. The parties in that case, Mr. Tomlin in that case, acceded to the use of the term renewals or extensions. He's a real estate professional. He understands what that means. It means what Doric Building and Key say. And that's the problem with that argument. We have what Doric Building said. Doric Building said, and lawyers and the real estate community rely on this, it says it's a renewal or extension unless, it's not a renewal or extension unless it expressly states that it is. That is specific terminology. That's not equivalent to saying if the parties amend the lease. If that's what the Doric Building Court had meant, they would have said it. But when you say that there's a requirement that for the unless clause to apply, it has to expressly state it is a renewal or an extension, that's different. And that did not happen in these cases. Turning back to the analysis under Key, we think it's important, let me say one more thing about the unless clause. The application could lead to some pretty absurd results, and it would probably have a pretty big impact on the real estate community if they were to find that all of a sudden they are liable for commissions they never anticipated, and that is this. If you have a lease under the Chancery Court's interpretation, if this court affirms, you have a lease that changes the rent, changes the leasehold space, adds new escalation clauses, does any number of material things, then that typically would be a new lease under Key and Doric Building, except if the unless clause applies, not because the lease says it expressly states it, the parties may decide, I'm going to avoid that language because I don't want this to be a renewal or extension. However, if it has the mere effect of extending the term, if that's all the unless clause means, then there are going to be a lot of people in the real estate industry that are going to find themselves on the receiving end of a commission demand. I'll reserve the remainder of my time for rebuttal if there are no more questions.
Thank you. Mr. Delaney.
Robert Delaney for the appellee, my co-counsel Tim O'Connor. Good to see you gentlemen today. We'll have to start out by saying I was going to start out differently in terms of how I prepared for this, but listening to Mr. Kimball, who's a fine lawyer, and we've gotten to know each other throughout this case for a number of years, I'm going to start in a little different direction. He and I read the record in this case differently. Refer the court to the Chancellor's memorandum in original order that was entered in this case. As he goes through his findings of fact and so forth, he seems to have a very consistent theme in terms of why he ruled one way on one lease and a different way on other leases. And as I read his findings of fact, and I think that those findings of fact are supported by the record in the case, the leases that he determined that Mr. Tomlin was entitled to commission on refer to and in some cases incorporate the original lease. As to the other leases that were renewals or extensions that did not refer to the original lease or incorporate some of its terms, he determined that those leases or those renewals did not entitle Mr. Tomlin to a commission. And so the court found, of course, that Mr. Tomlin was entitled to about $192,000 and change in commissions. And of course, the key here it relates to, I suppose, the interpretation of Raskin v. Doric and Key versus Raskin. And it seems, as I read the appellant's brief, they take the position that the unless clause in the Dort case is dicta because in the case that Judge Cantrell wrote, the Key case, the unless clause was never discussed. And I respectfully disagree with that interpretation. The unless clause in the Dort case is clearly a very significant matter. Judge Cantrell refers to the Dort case as the leading case in Tennessee when he wrote Key. And the reason I submit that the unless clause was not discussed in Key is because it really had no application. The court will recall that in the Key case, Mr. Key was a broker with Edwin B. Raskin, and he brought in a pretty good customer to the Raskin business, St. Thomas Hospital. And they negotiated a lease initially for 5 years, and then there were to be three options to renew for an additional 3 years under each option. At the end of the 5 year, and in the event that you wanted to exercise that option, you had to do it 120 days in writing before the leases ran out, or before the lease ran out. The lease ran out. The options were never, ever exercised. And so inevitably, the lease that was subsequently negotiated with St. Thomas Hospital had to be a new lease. And so the unless clause never, or the unless language out of Dort never came into play.
Counsel, I want to ask you the same foundational question I asked your opposing counsel in this case. Does it matter, outside of this context, and I understand it matters greatly in the context we're currently in, does it matter in general conventional landlord-tenant issues whether we call something an extension, a renewal, or a new lease? Is there any independent legal significance to that labeling outside of the context of the type of questions we have before us in this case?
My answer is different, as you might expect from Mr. Kimball's on that. I don't think it does. The initial work was done. I mean, the facts of this case, Your Honor, are as follows. You had a number of doctors who were trying to start a new business entity. They had to get it up and running in top-notch speed between September of '97 and May of '98. And they hired a guy who was experienced to do it, who obviously used, I think undisputedly, his expertise and background of 25 years as a commercial real estate guy to get in and get 7 or 8, as I recall, new renal treatment facilities up and running before the May '98 deadline that would have required Dr. Himes and Dr. Tannenbaum to continue on with their current employer. And so, he wrote this, or the contract that we have here. I mean, as you know from having read the brief, we have an alternative argument here, and that is that this is not a true rental brokerage agreement. It's a consulting agreement. If you look, I mean, there's some confusion in the record, as you will have picked up. One of the issues the chancellor decided, of course, was which of two agreements controlled, and he ultimately held that the consulting agreement was the last agreement written on the same subject signed by all the parties, and therefore it was the controlling agreement. And if you look, and there's 2 paragraph 2s in that agreement, which is confusing, but the first paragraph 2, as I recall, relates to the scope of the work that Mr. Tomlin and the Tomlin Company was to do. And it was far beyond just negotiating leases. He was supervising construction. He was negotiating deals with investors. He was superintending construction. He was doing a number of different things. And so we would respectfully submit to the court that really, while a lot of the discussion and debate in this case has been about brokerage commissions, that the contract is much broader, as your question suggests, than that of a brokerage commission contract merely.
So thinking about the unless language of Doric here and these sort of magic words of renewal, extension, do we have the agreements in this case? Do you agree that the agreements do not include the language, whatever, and you're disagreeing about what they are, but do they have the magic words of renewal, extension in them?
Well, it so happened I just brought a copy to the lectern of the agreement, and in paragraph, the second paragraph 2 of the consulting agreement, 2A says the company shall pay a consultant a 4% commission on the gross rentals of all leases upon signing of the lease and at the renewal or extension of such leases.
And the agreements that are subsequently reached here by Nephrology Associates, whether they're renewals, new leases, extensions, did those have the magic words renewal, extension in them? So if pull out the agreement as to the Gallatin office or as the East Nashville office, is it going to say the word renewal? Is it going to say the word extension?
I think the answer is yes to that, according to the Chancellor's findings in his memorandum in order. And he basically says that they talk about renewing or extending the original lease by adding certain terms. And I think the reason the Chancellor found that those leases didn't constitute substantial increases of the obligations and duties is because they were essentially the same leases. Those are his findings of fact. I mean, that is the consistent theme all the way through how the Chancellor, I think, decided this case.
Is renewing, and this may seem like a very, very small line, and it may be too small of a line. Is there a difference between an agreement that says it's renewing and an agreement that is labeled a renewal? Or if it says renewing, is that a renewal? Is there a difference between extension and extending? Or are those the same thing?
Surely it's not. I mean, because basically what you're doing is it's a continuation in either case of a lot of the original terms that were negotiated, in this case, by the consultant who was Mr. Tomlin.
So if it says, it'd be your position then that if it says extending or renewing, we have that magic word of renewal or extension.
I think that's right. I mean, effectively, even and I would say beyond that, I must say in all honesty, I haven't gone back and reviewed every lease in the record prior to this oral argument today, but again, relying on the Chancellor's findings of fact and conclusions of law, it's clear that the intent is expressed that the original lease is to be renewed or continued or extended by virtue of the second lease that's being entered into, and on that basis, he found that that Mr. Tomlin and the Tomlin Company were entitled to commissions.
I have Judge McBrayer's question from earlier that has me concerned in the context of what we're looking at. I've been referring to these as magic words, and if we're talking about terms of art within industry, do we have anything in the record here that's going to tell us that it's understood in the industry as a magic word, that if you use renewal or renewing or extension, that it's not a functional test, but instead it's understood within the industry that would, is the record going to reflect one way or another on that question?
I'm not sure directly, to be honest, in terms of trying to answer your question. There is testimony by Mr. Tomlin about practices within the industry. There was some suggestion that our alternative argument has been waived because we didn't advance it at trial. That's not correct, I would respectfully suggest. Mr. Tomlin's testimony, I think, is important about that. He testified about his background. He testified in terms of what his anticipation was as it related to the terms of these two contracts. The first, of course, was a letter agreement, which was not very elaborate. Second agreement, of course, was drafted by Mr. Steve Harrison's lawyers, Baker Donaldson, John Gupton, and Phil McSween, both very good lawyers, and so I think that there is some. I would direct the court in reviewing this matter to, or I would direct sounds like a too bold a word. Let me go back. I would respectfully suggest that the court take a look at Mr. Tomlin's testimony carefully about that, because he does go into some background about that. I'm not sure his testimony is as direct as your Honor's question.
So the first agreement says renewal. The second agreement says renewal or extension.
That's true.
And Womble against Walker says, well, extension is basically a renewal. So they really made no change in that agreement by the addition of or extension language, is that?
I think that's right. I mean, there's a debate, about really what.
So these wise lawyers at Baker added a word to or extension, and it really didn't mean anything, is that?
I don't think it did. I think it does not. I mean, effectively, it's. There was an argument made. The first disputed issue the Chancellor decided was whether or not Mr. Tomlin had to negotiate the renewal or extension in order to be entitled to a commission. Steve Harrison testified that he did. Mr. Tomlin testified that he did not. And in fact, the language of the second paragraph, 2A, in the consulting agreement says that that the determination about commission is going to be based on the original amount that the consultant, who is the Tomlin company, negotiated. So the Chancellor found that Mr. Tomlin didn't have to negotiate the second extension.
Is there anything in the record that suggests that the parties had any idea about the Raskin cases when they were drafting these agreements?
No, sir, I don't think so.
They were really counting on those two definitions of what a renewal is or what an extension is.
The record would be silent about that.
Yeah, and so let me ask you one. I know your time's up, Mr. Delaney, but I want to ask you about, in the appellant's brief, they go through and list the substantial changes, riffing off the language from the Doric building case. What's a substantial change? And, I'm looking at all of them, and I pause at that East Nashville lease where it says there's the premises leased are larger, and that makes me think, oh gosh, that looks like a substantial change there. Why is it not?
I think in that case, the Chancellor relied on the fact that it was that the terms of the original lease, despite that change, were going to be followed, at least in part, with respect to the
additional space.
Yeah,
because it's not an insignificant increase in the lease space.
I agree, and and as I read the Chancellor's reasoning, and I know I'm out of time, but if I may finish this question, please. I think that to the extent that the Chancellor found that the lease the new lease was essentially a continuation in whole or in part of the first lease, or referred to it as being a renewal or extension, that he just assumed, his assumption is that there therefore was not a substantial change in terms of the obligations or requirements in terms of the first. I don't think he analyzed specifically what each of the individual changes were, and I think that he was entitled to do that. I might just point out one other thing, if I may, and I don't mean to read to the court, but in the Doric case, the court specifically says, in addition to the language of the 1987 lease, does not indicate that it was intended to be an extension of the 1973 lease. So So Judge Hires, when he decided, Dorick attached great significance to this idea about, what I assume really the intent of the parties is what you're talking about. And to the extent that the language to the extent that the language refers to the fact that it was an extension or renewal of the previous lease, then I think that that is of great significance. And I don't think the opinion that Judge Cantrell wrote, excuse me, I'm dating myself, applies or is dicta in key for the reasons that I've already argued.
Thank you.
Good to see you.
See you too. Mr. Kimball.
I'll just respond to a couple points. Mr. Harrison, who at the time he was deposed was a former executive of the appellants, did testify that his belief was that Mr. Tomlin had to personally negotiate the extensions. However, we have never taken that position in this case. His testimony, his belief on that is his business. We do not take the position, and have never taken the position, that Mr. Tomlin had to personally negotiate these extensions to be entitled to a renewal commission under the agreement, provided that it was actually a renewal or an extension. I will say that the argument that the Chancery Court was wrong in not limiting its review to the NNA agreement, but rather looking at Key and Dorick for a definition of renewal and extension was in fact waived under Rule 27A4 of this court, and that's not properly before the court. Finally, I'll mention that the Chancellor specifically said in his findings of fact that the Springfield lease expressly stated it was an extension. He was wrong about that. It does not use the word expansion, or extension rather, anywhere in that document. None of these 7 leases, or any of the others for that matter, the ones we won on, state or use the words renewal or extension anywhere.
So what about extending or renewing? And is renewing the same thing as renewal? Is extending the same thing as extension? I mean, it seems like does that language appear in any of these agreements?
No. What it does say is, like most lease amendments that extend a term say, is the term of the lease is hereby extended. That's what it says. That's all it does. So the Chancery Court applied the unless clause not on what the document said, but on what it did, which is inconsistent with the language in Dorick Building. Thank you.
Thank you. Thank you both. Would you call the next